Another day, another headline. Pull up a chair, come on in. Different minds around the table. Let's see where the night begins. Questions welcome, ideas welcome. Everybody gets to say. Leave with better questions than the ones you brought today. Community, unity, learning, thinking. Welcome to the following, where good logic has a say. Think a little, laugh a little, grow a little today. Not at all. The leader of the following, not at all. A cult type of cult. Hey! Type of cult. No Kool-Aid, no spaceships, no squirrel mutilations, no sacrificing goats. Tracksuits not mandatory, just highly recommended. Buy a hat, buy a mug, link in the description. No throwing virgins into volcanoes, no dancing around a bonfire while shucking off clothing in the middle of the forest to the beat of a tom-tom, beat of a tom-tom, beat of a tom. Not at all a cult, type of cult. If the stream suddenly goes sideways, Joe Boomered again. Community, unity, learning, thinking. Pull up a chair, stay a while. Welcome to the following, where good logic has a say. Think a little, laugh a little, grow a little today. Joe is not at all the leader of the following, not at all a cult type of cult. The following program starts now.
Good evening, everybody. Welcome to the following program. I am your host, Joe Neerman, aka GoodLawgic. I hope you all had a phenomenal weekend. To me, my summer is over. I know it's August, it's the middle of August. My summer is over. I think I'm done with the mountains. I don't think I'm going back. I know Labor Day is still like a few weeks off. My summer is pretty much over. And I'm okay with it because really there's not very much difference between summer and fall. Or it's just more the same in a good way. It's all good. It's all good. I'm good with fall. I'm good with spring. I'm good with winter. It's all the same. But the summer season, which gets marked by me making weekly expeditions up to the Catskills, seems like for the 2026 season has concluded. So, and it was great summer, great people, great company. Love hanging with my wife's family, which I get to see a lot of over the summer. They're all, each and every one of them, awesome. So yeah, great summer all around. Hope you enjoyed yours. Hopefully yours, especially if you look at summer's vacation, is still continuing and ongoing. Tonight, what we have going on is, I want to spend a lot of time talking about Luigi Mangione. Luigi Mangione, he who is the assassin, the killer, the stone cold-blooded killer of an health insurance CEO. Just hunted him, found him, killed him. Now we know, we can say it definitively. It's not allegedly it's no longer allegedly. My shirt is allegedly pulling on me, but it's no longer allegedly. It's definitive. He killed him. He admitted it in open court. And I want to spend a lot of time really fixating on why this is such an unusual legal strategy, and it's a very, very bold legal strategy that we really need to look at the law and understand a little bit about what their approach was, and was it the right strategy? And there's a lot to say about it. There's a lot to say about it, and I have lots to say about it. It's a fascinating strategy. You would think, you're sort of giving up the game. You're giving up the game. But they definitely, this was not a rookie error. This was not a rookie mistake. These are some of the most seasoned criminal defense attorneys on the planet who are employing a strategy here. We're going to talk about the likelihood of success of that strategy and whether or not that's going to work. Whether that's going to work for them. It's bold. It's definitely bold. Also, the DNC has embraced the radical position of saying, let's abolish ICE. I want to have a conversation with you about what that means. Why? Like, is that the right call? Is it going to enhance their chances in November? Is it potentially disastrous? Is it potentially like Harry Carey? Have they given up the plot? Are they more insane than Luigi Mangione's defense attorneys? Yeah, definitely that. But I don't think you need to stay tuned for that. But yes, it's definitely more insane. But what are the chances that works for them? So I definitely want to talk to you about that. Also, we have a goal tonight. The goal tonight is if we get our 15 super chats in quantities of $10 or greater. Need not be super chats. They can be rumble rents. They can be shekel dollars. Let's face it. You can just if you cram 100 into my mouth and ask me to squawk like a chicken, that works. I might not squawk. I might do a terrible job of it. If $100 bill, probably not. I don't know. We'll cross that bridge. We'll cross that bridge when we come to it. We'll cross that bridge. But if we get 15 of those, we're going to go into hour 3. During hour 3, I plan on going over the Eric Swalwell coming back in the news, plus other things that Trump exposed from intelligence agents' files that have been granted transparency and dropped on the world, and the journalists are scurrying, trying to figure out what can we take from this? What can we take from this? I was also thinking about doing a review of the Candace Owens things, because the Candace Owens debate and I was also thinking about doing that. I might do that during hour 3, a little sampling of that during hour 3, especially if there's interest in that, because on Friday I ran out of time. I had warned everyone that I was going to have to shut down and leave by 2:30. I ended up staying to 2:40 or so and just letting it play. And when I did that, and the next thing I know, my computer actually turned off. And it just kept playing for 20 minutes after the show ended. And then it just shut off on its own. So I never really got to put a little bow on everything with that debate and my thoughts about that debate. I weighed in during the breaks and different moments there. I definitely shared a lot of my thoughts, but I never really encapsulated everything. And I think that there is a lot to encapsulate. So if there's an interest in that, meaning if people who are donating, say, hey, we want to get your thoughts on Candace, I definitely can do that as part of hour 3, assuming we reach our goal. So that's our show for tonight. Also, a reminder to you all that you should be checking out Fourth Wall. You should, for all of your GoodLawgic needs. Link is in the description. Why the heck this is I'm looking at my description now. I'm looking at I think I got done dirty. I don't think I got the link in here. That's not good. That's not good. That's not good. What is that? Oh my goodness. That's this is it didn't work at all. All right. Well, I'm gonna have that sorted out at some point. Definitely gonna have that sorted out. Why did it do that to me. I'm looking at my description here, and I see that the link is actually very poorly done. I don't know if you can actually find the link there. That's not good. What the hell is that? I'm definitely going to fix this now. Definitely going to fix this because I feel like, you know, if people want merch, the people definitely have a right to merch. They definitely have a right to it, and you're not going to be able to find it otherwise. You won't find it. All right, so that link is fixed now. At least it's fixed over in YouTube. Oh, it's pathetic. All right. In fact, let me fix it here also. And my apologies for this. URS is saying no. I don't know what that means, but no, I guess the no is probably on Candace. That's what I'm guessing. I'm guessing the no is on Candace. People don't want more Candace? You don't want more Candace? You don't want more Candace versus Andrew Wilson? All right, I fixed it there. Let me pin it in the chat. All right. And yes, I pinned in the ghetto first. All right, let's get started. I also can go over if we hit hour 3. If we do hit hour 3, I'll go over also Trump's appeal to the Supreme Court. And just give you a breakdown as to procedurally what's happening. I'm not going to go through his entire appeal, but over his mail, his preventing fraud through mail in our elections. The EO that's under scrutiny from Judge Talwani. But first off, I want to talk to you about Mangione. Mangione is first and foremost on my mind. This is where we're at now on Mangione, in case you're wondering. Mangione trial, the New York State trial for Mangione was supposed to commence next month, and that is now being paused. You don't see nothing, do you?
A New York State judge has postponed Luigi Mangione's trial on murder and weapons charges over the killing of a health insurance CEO after Mangione pleaded guilty last week to separate federal charges. The trial had previously been scheduled to begin on September 8th. Mangione has pleaded not guilty to the state charges. On Friday, Mangione's lawyers argued that he should not have to be punished for the same conduct twice under New York's law prohibiting double jeopardy. A New York State judge.
So that's the status. His murder trial has been put on hold. Now, frankly, from my perspective, I'm kind of pleased that it's been put on hold because I definitely plan on covering this trial. This is a trial I plan on going to New York for and giving you daily updates. Like I plan on covering this the way I would cover the Diddy trial, assuming we get to a trial, which we may not if they're successful in their motion. But I think that, and this really could be very effective in drastically postponing the trial, because we could be venturing into areas of law which are not really that well defined. So I'm going to talk a lot about what happened on Friday when he went into federal court and pled guilty. In fact, I'm going to read to you the entire transcript of that appearance so that we actually can take a look at exactly what he said and why he said it and try and do some analysis on that before we actually get into what the repercussions are of what he did and this whole strategy. But first off, Segan Rose, hi. Every once in a while, I have to do my Forrest Gump wave. Sorry, John, I don't believe Brian Thompson is dead. Oh, that's possible. Brian Thompson, the CEO, who who Mangione admitted to killing. I think we need to chat Paul. How many people believe he's actually dead? And how many people think it's a Luciferian theater? Look, I'm not here to tell you that Brian Thompson is a good guy. I'm not here to tell you that he's a good guy. That's not the issue. The issue is not whether or not he's scum. Okay, I have no reason, by the way, and you have no reason, almost certainly, to know that Brian Thompson specifically is a bad human being. Do you know anything that he did while he was working for the company? Did you ever hear the name Brian Thompson before he was murdered? Like, as far as it's very easy for us to look at, I think it's a little bit of a leftist thing to assume rich person equals evil, or rich person working for a company I don't like equals evil. The reality of the situation is that our current situation with our healthcare was all constructed by Barack Obama. If you don't like the way our healthcare companies, our insurance companies are operating, you shouldn't be taking out on Brian Thompson. You should look at Barack Obama. And I'm definitely 100% not urging anyone to take it out on Barack Obama, but it's his plan. It's this entire mess of our medical care system that we are currently living under today is exclusively the fault of Barack Obama and the Democrats. They purposefully set up a system that they knew was going to fall apart and that it would basically last for 10 years. And it did. And then they had to keep subsidizing it until Republicans are like, we're not subsidizing this anymore. So this was a mess from inception. This was like an abortion from the moment of conception. It was a planned disaster zone that would just grow and grow and grow into like the metastasize into like this disgusting, evil thing that's crooked and deformed, which is our current medical insurance system. So, now Brian Thompson certainly did. I doubt he did much to help the situation. With him gone, do you think that does anything to the insurance companies? Do you think they're going to act in any way whatsoever? You think there's been any change at all? He was killed a couple of years ago. Has there been any change? Has it been made better? You cannot definitively point to a single individual on God's green earth whose life is better off because Mangione executed Brian Thompson. And we can point to people who are definitely victims, aside from Brian Thompson himself. Yeah, for all intents and purposes, we have every reason to assume his wife and children are actual victims. And worse than that, have to live with the fact that because he's the guy who was killed, he's the one who gets maligned. And this gets me a little bit annoyed. Whatever you think about insurance companies, and yes, they are blood-sucking vipers. Okay, they're they're all about the money. That's all they are about. And whatever will make them an extra nickel, irrespective of injuries to life, limb of the public writ large, they will suck and suck and suck. Okay, and they are the grossest form of capitalism. They are the grossest manifestations of what capitalism can breed. I'm with you. I'm with you on that entirely. That being said, he's going to be replaced by someone else. And every one of these people complaining about capitalism, if they had an opportunity to be in his shoes, doing what he does, or being the guy who replaces him, they would do it themselves, because that is part of human nature. The problem is not capitalism. The problem is the system that was set up for how we handle our health insurance. That's the problem, which you can look, again, back to the Democrats. But what annoys me, frustrates me, is I look at his widow, I look at his kids. How many CEOs of health insurance companies are there out there? Hundreds? Thousands? But you know which one gets maligned more than any of them? More than all the rest of them put together. The guy who was killed, the guy who was assassinated. That's the one who we're specifically targeting. Oh, he's pure evil. Yeah, it's kind of sickening. It's kind of sickening. The one who's dead, the one who got killed, is the one we're calling out as being purely evil in comparison to his brethren in the industry. No reason to assume that any one of them is any better than him, but no one knows their names. No one can point to that corpse, to that individual who's a blood-sucking vulture for something that's still blood-sucking to this very day. No one points at that person today and says, oh, that person's evil. The one who's uniquely evil is the one who got assassinated. It's very twisted. It's very twisted. So, yeah, I'm not a fan of Brian Thompson specifically. I don't know the first damn thing about him, other than that he was CEO for a health insurance company, but I don't know anything more than that. I doubt you do either. I doubt anyone does. The jewels are coming on in. Here comes the jewels. All right. So I don't really get that whole take. But let's talk about. Let's look a little bit further as to his plea deal. Let's look at his plea deal. This was the announcement when everyone was trying to figure out what the hell was happening, when the story broke on Friday that the plea deal was coming down.
Luigi Mangione has just pleaded guilty to the stalking charges against him in federal court. So he says now he is prepared to plead guilty. And that is what's happening at this moment. So I want to get from you, Carrie, the semantics and difference. Because from the courtroom, pleading guilty, prepared to plead guilty. Are they haggling at this point? Is there some back and forth? Because you'll get that mixed response now.
There's no haggling that's going on. There probably was arguments in the prosecution about the language that was going to be incorporated in his allocution.
Coming from our team, is it guilty or preparing to, and is there a significant difference?
Well, now Mangione is going to have to explain what he is pleading guilty to. And that is important, as I mentioned earlier. In the case the double jeopardy argument fails, although I do think he probably has a strong case for
yes,
it,
he is.
given the stringency of the New York law. You know, any statements that he makes here as part of this guilty plea could be introduced into the state trial as admissions of culpability. Now, of course, the defense would raise objections and the like, but you know, one thing that we need to remember, and I mentioned this earlier, is that the judge who's overseeing this, you know, she is an alum of the DOJ office that is representing the federal government's interests here. And she was also chief of criminal appeals at SDNY. So she knows all of the pitfalls and the problems that could occur. So she's going to be especially careful as a former prosecutor from this office herself.
All right.
Meaning that in his allocution, that the judge is going to try and keep the defense from being able to present anything that would help bolster their claims that the murder charge on the state level should be dismissed for double jeopardy.
Defense attorney Karen Agnafilo has just stated, quote, Mr. Mangione is prepared to plead guilty to the indictment at this time. The judge then asked Mangione, he confirmed, saying yes.
By the way, while we're looking at this picture of the court district in downtown Manhattan, gives me an opportunity to flex a little bit on the location that I've traversed many a time. If you're wondering where the courthouse is, like what each of these courthouses is, this over here is the federal courthouse building. This is the state courthouse building next door. This is 40 Center Street. This is 60 Center Street. If you walk down this block over here, one block down, like basically over here, is 500 Pearl Street. And that is the address for a different federal courts. That is the courthouse where, that's the courthouse where the Diddy trial was. There's two different buildings for the federal courthouse. So there's this one over here at 40 Center Street. This is where the Ghislaine Maxwell trial was, in this building, like on one of these higher floors here. And the Diddy trial was on the 25th floor over at 500 Pearl Street. This is the courthouse I've frequented I've frequented many more times as an attorney, because I had a lot of stuff in state court. So whenever I had to file a TRO or something like that, would run down to Manhattan State Court. There's a long corridor you walk down when you get in here with the security. So yeah, so that's the courthouse. This is the court district. Now the normal state criminal court, this is state civil over here. State civil is at 6th Center Street. The criminal court is actually a block further north, which is this street is going from south to north. So it's a block further north at 100 Center Street. So it's basically on this corner, the next corner over.
So the judge said, is that the truth to Mangione? Mangione confirms yes. So give me, if you can, Carrie, just what happens now for Mangione's team. You heard Jonathan saying that, well, his hands are free. That may be why he's shackled. We haven't confirmed that yet, but our producer says it appears his feet are shackled so that he can write notes and talk. Would they have already worked this out before they got into the courtroom today, or would this be a real fluid situation right now?
Well, presumably they're going to go through the elements of the crime and the facts that support those elements. And look, you know, I have to say, Mangione's defense team has done a very good job up to this point. Think about what they have done for him thus far. They got rid of the terrorism charge. They got the death penalty off the table.
And these are serious wins that his defense team, like I said, you're not going to find better defense. You're not going to find this is like, not to knock any other defense counsel. I mean, they're very high priced defense. Okay, he's got like the best defense money can buy. This is like, you know, the Diddy defense team effectively. In fact, Agniflio is, I think, a daughter of the attorney who represented one of the attorneys who represented Diddy.
They got mandatory life sentence.
I'm not sure his daughter or his spouse.
Off the table in this state case. So they have demonstrated significant strategic, I would say, ability and skill. And so I think what they're doing here, they must believe it's their best shot for a number of reasons, many of which have already been discussed.
Okay, so they say it's already been discussed, but we have not discussed that at all yet. Let's take a moment to take a look at exactly what he said. So we're going to read through the transcript, this is the transcript of his plea allocution, so we can see exactly what he said when he went in there. All right, sir, this is the court. All right, sir, I'm going to ask you now to tell me in your own words, what did you do that makes you believe that you are guilty of these charges? This is after his attorneys had already told the court that he wants to plead guilty to the charge of aggravated stalking and across state lines. And if you're going to read, I just remind you to read slowly. Sometimes even me reading a script, when you are reading, people tend to read more quickly. So just take your time and read slowly. Go ahead. It's entirely up to you, Mr. Mangione. If you would like to stand, you can stand. And if you're more comfortable sitting, that's fine. I'll stay seated. Okay, go ahead. This is Mangione talking. After years of enduring severe pain from a broken back, navigating the obstacles of the health insurance system, and witnessing similar experiences of countless others, I learned that the United Healthcare would be holding its annual investor conference in New York City on December 4th, 2024, although the specific location was not publicly disclosed. I'm sorry, Mr. Mangione. I'm sorry to interrupt you. I'm just having a little bit of trouble hearing you, and so maybe back up a little bit from the microphone. Back up? Okay. And just try to keep your voice up. The last thing I heard was that you learned that United Healthcare would be holding an investor conference in Manhattan in December. Go ahead. I learned that United Healthcare would be holding its annual investor conference in New York City on December 4th, 2024, although the specific location was not publicly disclosed. I then researched the event online. I observed that the annual a conference of America's largest healthcare organization with the stated mission to make with the stated mission to make the health system work better for everyone, would be attended by company executives, board of directors, and hundreds of investors, not doctors, nurses, and patients. In November of 2024, I traveled from outside of New York State to Manhattan. I then emailed United Healthcare leadership posing as an investor at a firm managing over $50 billion in assets. So he sent an email claiming that he is a massive investor and requesting information about the conference. Unlike my previous interactions with insurers, I received an immediate response within an hour. Before traveling to New York, I used a 3D printer to make a part of a gun, and I equipped the gun with a silencer and a magazine. My travel to New York and email to United Healthcare was with the intent to shoot Brian Thompson. On the morning of December 4th, 2024, I shot Mr. Thompson in Manhattan, and he died. When I did so, I understood that my actions would place him in fear of death or a serious bodily injury. I knew what I was doing was illegal. Basically, this is a checklist of the elements of the crime for criminal stalking, as we're about to see. We'll just finish this up first. The court said, Ms. Friedman Agnifilo. So I think she's probably married to Agnifilo, the one who was. Are you aware of any valid defense that would prevail at trial, or do you know of any reason why I should not allow Mr. Mangione to plead guilty? And that's his lawyer says, no, Your Honor. Mr. Gentile, are there any additional questions that you would want me to ask Mr. Mangione? No, Your Honor. Does either party know of any reason why I should not accept the defendant's plea of guilty? Mr. Gentile. No, Your Honor. Ms. Friedman Agnifilo? No, Your Honor. Mr. Mangione, how do you now plead to counts 1 and 2 of the indictment? Guilty. So there you go. There you go. As crystal clear and concise as you could want to be if you want to expressly check off the elements. Let's just review here what the elements are. Because he's pleading guilty to 18 U.S.C. 2261A, which is stalking. Whoever travels in interstate or foreign commerce, or because in order to make it a federal crime, you need to have some sort of interstate activity, right? It can't just be someone walks up to someone. So you need to have some sort of relation to interstate activity. So whoever travels in interstate or foreign commerce or is present within the special maritime territorial jurisdiction of the United States or enters or leaves Indian country with the intent to kill, injure, harass, intimidate, or place under surveillance with intent to kill, injure, harass, or intimidate another person, and in the course of or as a result of such travel or presence engages in conduct that places the person in reasonable fear of the death or serious bodily injury to that person. So in that case, and number 2 is with the intent to kill, injure, harass, or intimidate, or place under surveillance with intent to kill, injure, harass, or intimidate another person. Uses the male. So this is not relevant to this. So basically, if you travel interstate with the intent to harass someone or to place them in reasonable fear of death or serious bodily injury, that's why they choose this particular language, right? If you look over here, what he specifically said, he said, I understood that my actions would place him in fear of death or serious bodily injury. That's why they choose such weird language. They're specifically trying to tick off this box to say this element met, and that's why he should be found guilty. Now, there's an enhancement for this, which basically is if in fact it results in their death, that you have a maximum of life in prison, which is what he's looking at his sentencing hearing in December. That they want to basically, the prosecution is undoubtedly going to demand the maximum, saying how this was just a willful execution and that he should get the maximum. Okay. So all of this is basically, in sum and substance, what happened on Friday. Well, there's a little bit more as to what happened on Friday. Let's hear from attorneys who, from right after he made the statements. This is Mr. Gentile and Ms. Friedman Agnifilo.
The defendant committed this murder in an attempt to draw public attention to his dislike of certain businesses. But we live in a civilized society governed by the rule of law. We debate, we disagree, we protest. We do not commit murder. No grievance, political belief, or ideological cause can ever justify murder. There can be no celebrity in assassination. Any person who celebrates, encourages, or excuses actions like these is fundamentally wrong. The second shot came as Mr. Thompson turned and faced the defendant. Mangione attempted to send a public message through violence, but the message that emerges today is very different. Violence is not a legitimate instrument to promote any political or social message. And those who resort to violence in an effort to advance their beliefs will be prosecuted, convicted, and put in jail.
Today is
Now that was prosecution. Here is his defense counsel.
a solemn and significant day. With today's guilty plea, Mr. Mangione has accepted full responsibility for the death of Brian Thompson, arising from the events of December 4th, 2024, outside of the United Healthcare Investor Conference here in Midtown Manhattan. It was a single tragic event, yet he...
And I know you're looking at this and you're thinking New York lawyer, and you see the nose, and you're probably reaching certain conclusions. I'm just going to point out Agnifilo is not a very Jewish name. Now Friedman, on the other damn it!
He's being prosecuted twice for the same conduct. He endured years of severe...
It looks like a fake news.
Despite this being a single isolated event, Mr. Mangione has been unfairly treated since the outset in every way and has successfully...
The dude is literally an executioner, unfairly treated. The dude's a monster. He's an executioner who had to be hunted and located.
fought off terrorism charges and the death penalty, while also fighting at the same time...
He's an executioner. He issued the death penalty to Brian Thompson.
Two simultaneous prosecutions in two jurisdictions who are trying to punish him twice for the exact conduct. He's been treated differently.
It's not the exact conduct, and that's the issue here. It's not. It's one action, but different types of crimes.
Differently from every other defendant charged with this offense in New York. However, thankfully, New York law does not allow this. New York law does not permit a person to be prosecuted and punished twice for the exact same crime under a statute that governs successive prosecutions. It's also known as the double jeopardy law.
Now, double jeopardy is both a United States constitutional thing from our Bill of Rights, and it's also enshrined and codified in far more broad protective of defendants' perspectives in New York. In fact, as we're going to learn, New York arguably has the broadest protections for defendants with respect to double jeopardy. And that certainly was a factor for these attorneys when they pled.
Today's guilty plea triggers this statute, and we just filed our motion in state court explaining why the state charges must be dismissed under New York's double jeopardy protections.
The moment that he pled guilty in federal courts, before even getting outside, they had their people file. I don't know if they e-filed or in criminal court. I remember when I was covering the Trump trial and I was trying to find documents from all the filings from his litigations in New York, particularly the criminal litigations. It's a nightmare. And what I learned about criminal defense, because I'm not a criminal defense attorney, but what I learned about the e-file system for New York's criminal court, and in stark contrast from civil courts, very stark contrast from civil court. Civil court, you see every filing. It's very easy to find, really easy to find. In state court, in New York State criminal court, they don't upload anything. Anything. So I don't even know if you e-file. I assume you e-file. We've had e-filing here for 20 years, 25 years now. I mean, they basically started e-filing like the day I became an attorney is when e-filing became like a thing, like a year or two after I got admitted. But as far as apparently there's like a 10-year backlog in the criminal system, which is why they don't even try to upload it online. Meaning, when I upload a document into New York State New York State Supreme Civil Court, you'll see it. You can click it right away, and it gets processed by clerks before it becomes like an official document, usually. But the e-filing itself like triggers like you're complying with your deadlines if you can prove that you e-filed it, and that's considered the filing. There's no hard copy that's filed. It used to be when they first started doing it, you had to e-file and file a hard copy. At a certain point, they said, okay, we don't need you to file the hard copy, just e-filing is sufficient. And sometimes if it's an emergency thing, in order to save the judge or the judge's clerk some effort, you would come down with a hard copy in order to like make life a little bit easier and be a little bit more popular there with the clerks. So you would bring a hard copy, but it's not a necessary thing in many circumstances in New York Civil. I don't know how it works in criminal courts, but I'll tell you right now, if you can e-file, they were literally e-filing. Like they walked out of the courtroom there and said, all right, he just pled, file now. And before they even got outside, it's been filed. Meaning what's been filed? The motion to dismiss the murder charge in New York State's criminal courts. So I'm sure they probably took care of it, e-filing and a hard copy, because like I said, it's just a half a block over. It's not that hard to do. So that was her statement there as far as that they filed this motion. How big a motion? It's a 62-page motion. And we're gonna look at parts of it. I'm not gonna look through the entire thing, just because I don't want to go through. I just don't want to go through all that. We are gonna go through this motion that they filed, that she just referenced, that they filed on August 14th. So we're gonna be looking through. This is Karen Friedman Agnifilo, and we're gonna look through that momentarily, particularly the parts about double jeopardy, which is the most interesting part from my perspective. But we're gonna hear some legal arguments from different people, and I'm gonna weigh in with my thoughts on this, because this is a really interesting question. And for the longest time, I was always very bothered by the notion that I'm like, it bothers me that there should be a double jeopardy. Bothers me. With Fifth Amendment protections away from double jeopardy. So the idea of there being double jeopardy bothers me a great deal. And the question is, it's one action, but that one action has several different repercussions. So are we going to look at this as you're hitting them with two different crimes, or you're looking at it as just one crime? I remember when I was looking at Derek Chauvin being charged both federally and on a Minnesota state level for the murder of George Floyd. And I'm just like, this feels like double jeopardy to me. It really does. Now you have to ask yourself, why would he do this? Even if it's double jeopardy. I just told you that the penalty for this is up to life in prison. How much worse can that possibly be than the murder charge? I mean, how much better is it off? How much better off is he? Well, the arguments as to why he would be better off with a federal conviction and getting rid of the state conviction is twofold. Number one, there's no minimum threshold. So if they get a judge who's sympathetic in sentencing and it's his first offense, perhaps he'll get a lighter sentence. Number two is the federal penitentiary is generally considered to be a much less toxic environment. You end up in club fed. You know, they some of the prison systems that they have is considered far less like it's like a resort practically. And he very likely could find himself in a much cozier prison. You and I just think, oh, okay, he's in jail, No. It's like, you know, if one is basically like, you know, from the TV series Oz and the other is, you know, club fed, this is not the same experience. So if he's able to find himself in club fed for the next 15 years rather than spending the balance of his days in Oz, that's a whole different existence. So I'm just torn about whether I want to go through the arguments first, or let's read through. Let's do a little reading first. I think that's the better way to do it. As we pull open this motion here, as I said, I'm not going to go through the entire thing. You pretty much have the whole history. It's a very well written motion. It's written as if it's drafted by people who you can understand why it is that they're charging $1,500 an hour or whatever it is that they're charging. So this is the affirmation support of the motion to dismiss, and you have a table of contents, and she goes through the whole history here. I don't want to go through the history with you, but basically she goes through arrested in Philadelphia, state and federal authorities charged at the same time. Mangione appears first in federal court, placed in federal custody, then federal New York State charging documents, and he goes through that. And she's going to talk about the overlap as far as the elements here. And that she's going to keep hitting on the fact that this was like, she's going to try and portray this as over aggressive prosecution for one action that he did, which was, you know, one morning he goes out there and kills a guy, and you have two different agencies which are trying to call him a terrorist or give him the death penalty, and how they had to fight off and fend off all these different over aggressive charges that the courts have recognized is not something that he's liable to face. He's going to have to deal with these charges. And she goes into the due process violations. I don't really want to focus on that so much, to me, because that's not relevant so much to his charges here. It's not relevant to the fact that he pled guilty on Friday. What it is relevant, though, is the double jeopardy charge. So we're gonna take a quick look at the arguments that she makes, starting on page 19 over here, and move forward. How is this? That's page 19 of this thing. All right. New York's double jeopardy law requires dismissal of state murder and weapons possession charges. In addition to violating due process, continuing the state prosecution after Mr. Mangione's federal plea also violates New York's double jeopardy law that provides a type and degree of double jeopardy protection not historically provided by the U.S. Constitution. Again, this is a reminder that New York has a much broader protection for defendants from double jeopardy than just your basic U.S. constitutionally protected right. The greater protection provided by CPL 4020 against dual sovereign prosecutions has been long recognized by the New York State Court of Appeals. I can pull up for you here this particular statute that they're referring to, which is over 40-20. New York Consolidated Laws Criminal Procedure Law. A person may not be separately prosecuted for two offenses based upon the same act or criminal transaction unless, so this is your basic double jeopardy. So it's the same act that would seem to apply. In order to attach here, it seems like it's going to have to fit into one of these unlesses. Unless the offense is defined to have substantially different elements and the acts establishing one offense are in the main clearly distinguishable from those establishing the other. So start with this. He cannot be charged, right? It's a one criminal transaction. He cannot be charged twice unless, so if you're the prosecutor from the state of New York, if you're the district attorney, you want to prosecute him, you have to find one of these unlesses that's going to fit for you. So what's one of those unlesses? The first one is that offenses have substantially different elements and are acts establishing one offense are in the main clearly distinguishable from those establishing the other. Or B, each offense as defined contains an element which is not an element of the other. And the statutory provisions defining such offenses are designed to prevent very different kinds of harm or evil. So what does this mean? Well, when you're looking at a crime is any crime you're looking at, you have to have a checklist of elements. We started checking off those elements to show how he had violated the federal statutes, and that's what he was confessing to in his allocution. So what he's confessing to, some of that has, at the very least, has overlap with respect to the state charges. So in order to basically get around double jeopardy, you have to show that there's at least an element which is not an element of the other. And the statutory provisions defining such offenses are designed to prevent very different kinds of harm or evil. And we're going to spend a lot of time focusing on this B. So I think this is likely where the state prosecutors are going to respond when they try refuting this motion to dismiss. The other stuff here doesn't really apply. Like one such offense consists of criminal possession of contraband. No, that's not really talking about when there's drugs over here. One offenses or some other offense resulting in physical injury to a person. The other offense is one of homicide based upon the death of such person. Maybe they'll go there. Maybe. We'll try and see whether or not that might help out the prosecution here. Or each offense involves death, injury, loss, or other consequence to a different victim. That's not relevant here. You would need to have more than one victim for that. One of the offenses consists of a violation of a statutory provision of another jurisdiction, which offense has been prosecuted in such other jurisdiction. Also doesn't seem relevant here. So I think we're really focusing on A, B, and D. Substantially different elements, and I don't know that we're going to hit on A because I don't know that these are substantially different elements. Somewhat, but it's to prevent very different kind of harm or evil. This is where this is where the entire fixation or much of the fixation is going to be. But I think some of it also could fixate, and I'll explain to you as we're going through the papers and the different arguments that we're going to hear on this. So you can be the judge. You can basically decide for yourself, what do you think should be the situation here? But that's basically This is the key statute, the New York statute that they're focusing on here. I don't even know which of these. It's almost like there's a war here. What if Trump issues Mangione a full and unconditional pardon? Can he then be prosecuted in New York? That's a really good question. That's a really good question. So that washes it away. I would think so. I would think so. But like I said, New York is kind of funky on this. New York's kind of funky. All right. So that's where they're citing the greater protection provided by CPL 4020, which we just read, against dual sovereign prosecutions has been long recognized by New York Court of Appeals. Specifically citing the New York Court of Appeals, in case you're wondering, is our nomenclature for referencing our court system in New York is a little bit convoluted. No, it's very convoluted and inverse from what you would think. If you're unfamiliar with how we refer to courts, our basic lowest level court, that in federal court they were called district court, we call Supreme Courts. Crazy, I know, but that's what we call it. So the basic level court we call Supreme Court. The first appellate level is called the appellate court, the appellate division, and there's 4 departments for that, covering different counties. There's 62 counties in New York, so they're apportioned that the first appellate division is Manhattan and the Bronx. The second department is Brooklyn, Queens, Long Island, Staten Island, and then the rest of New York State make up the 3rd and 4th. So the highest court in New York State is what they're referencing here, specifically the Court of Appeals. Let me edit this. Is the Court of Appeals over here? God. That's the highest court in New York State. All right. And they cite so these different Court of Appeals decisions going back through the decades, which reference the New York State double jeopardy, and that how much broader it is than it is under federal constitutional law. The legislature, apparently dissatisfied with the federal formation, adopted in the criminal procedural law what is generally known as the same transaction test, which in its purest form prohibits a second prosecution to be based on the same transaction as the first one. So what they're basically saying here is, look, if you have one transaction, one incident, you cannot, under New York law, be charged twice. This is what they're trying to interpret CPL 4020 as saying, if it's one transaction, you start with the premise that it cannot be charged twice. Under New York's double jeopardy law, a person may not be separately prosecuted for 2 offenses based upon the same act of criminal transaction. To understand the scope of this provision, there are 4 terms that must be further examined: prosecuted, offense, act, and criminal transaction. The term prosecuted in this statute is defined as a person is prosecuted for an offense within the meaning of Section 4020 when he's charged therewith by an accusatory instrument filed in a court of this state or any jurisdiction of the United States, and when the action either terminates in a conviction upon a plea of guilty, and that's what they want to say is what happened now. That he's considered prosecuted. Until when you just charge him, that's one thing, but now that he's been prosecuted because you have this guilty plea, that now, as Attorney Freeman Agnifilo was saying, that now triggers the double jeopardy standard, because now we can say, hey, look, this is a person who's been prosecuted because there's a guilty plea. And proceeds to the trial stage, and the jury has been impaneled, sworn in, which is not really relevant. So, but the key here is really this part is really this part over here, that it terminates once you have a conviction of a guilty plea. That now makes it something that that now is considered prosecuted. CPL 43 decision 11 says the law is triggered when a prior prosecution ends in conviction by guilty plea, or once a jury has been sworn. As relevant here, the federal government charged Mr. Mangione by criminal complaints and an indictment, each of which were filed in federal court. Federal prosecution was terminated as of this morning upon a plea of guilty by the 2 remaining counts of the indictment in full satisfaction of federal charges. So what do you want? He's ready. He's got the guilty plea. The definition of prosecutor on the CPL 4020 includes the term conviction, which also must be defined. So conviction is the entry of a plea of guilty to or a verdict of guilty upon an accusatory instrument other than a felony complaint. So now we're going to say, even though a judge has not said he's convicted, and that's what we tend to think of as being conviction. In fact, when Trump was found guilty by the jury, I had a whole back and forth with Nate, the lawyer, trying to figure out whether he's considered a convict under New York state law, where I was taking the position he's not considered a convict until a judge sentences him, and he's never going to get sentenced because, in fact, Judge Merchan never ended up sentencing him. So I was saying he's not a convict. He's not a convicted felon. And I had a whole back and forth where and it was like a good faith argument that I had with Nate about this very issue. When you have this guilty plea or a finding of guilt by the jury, is that considered a conviction or not? And I was able to find statutes which were able to help establish that he's not considered a convict or convicted felon until the judge says this is your sentence. That is the conviction. So he's not considered a convicted felon. But I think it was actually this statute here, when we were talking about double jeopardy, where the law is in fact in favor of Mangione, that just the plea alone triggers double jeopardy. That's considered conviction under New York state law. So while in other states it would not be considered conviction, it probably is technically true that Trump is considered a convicted felon based on how New York defines the word conviction. So CPL 120, given this definition, the phrase terminates in a conviction upon a plea of guilty specifically includes a guilty plea even when the defendant has not yet been sentenced. And that, like I said, is the key argument that I had. Under penal law 1001, the term offense means any conduct for which sentence of a term of imprisonment or a fine is provided by any law of the state, by any law, etc. The term act is defined as a bodily movement. And the term criminal transaction means conduct which establishes at least one offense and which is comprised of 2 or more groups of acts, either so closely related in connection and point in time, or so closely related in criminal purpose or objective as to constitute elements of integral parts of a single crime venture. So if you're doing multiple things in order to commit a crime, that would be considered like you form the intent to kill someone and then you pull the trigger. So those are 2 different acts which complete a criminal transaction. The moment that your finger is pulling the trigger, you might not be thinking at that moment, but you might be looking a little different direction. But the moment that you pull the gun out, you're forming your intent. So you can see how all that together forms a criminal transaction. Based on these definitions, with exceptions that will be addressed below, prevents separate prosecutions by any sovereign where the offenses are based on the same act or the same criminal transaction. Significantly, the statute does not limit the preclusion to offenses that have the same elements or means of commission. So you don't have to have exact same elements, nor does the statute require that all acts committed as part of one offense be committed as part of the other, or that the criminal transactions be precisely identical. The two offenses need only be based on the same act or transaction. Okay, but then you have your exceptions. For example, there could be other aspects of conduct, like an act impacting interstate commerce in a federal offense, that would not exist in the state. In other words, you could say, what do you mean? It's not the same act. To violate the federal act, you had to cross state lines. There's nothing in New York's murder charge which deals with having to cross state lines. They're saying that that's not relevant to this analysis. That does not defeat the two crimes being based on the same act or criminal transaction. If that were the case, a federal prosecution would never lead to a preclusion of New York State prosecution, because there's always going to be that interstate element. Rather, the same acts or criminal transactions need only be the basis of two offenses at issue. Applying the CPL to the facts here compels dismissal of the counts 3 through 10 in this case. All the acts Mr. Mangione now has admitted to doing on the morning of December 4th were part of the same criminal transaction. Specifically, he possessed a gun, the magazine, and the silencer to shoot Mr. Thompson. This is why he talked about that part. The actions comprising, that's why he references the silencer, because that's an enhancement under the criminal charge in the state court. So they feel like, oh, okay, let's make sure he's being as expressive as possible, even if it's not part of the federal crime. So this way we can say this is part of his allocution. Now, does that work? If he throws in bonus stuff that's not necessary in federal courts, it would be necessary for elements in state courts. Does that now make it a double jeopardy? I wouldn't think so. I wouldn't think that's logical. But I'm also not sitting in the New York State Appellate Court. The actions comprising each of these offenses occurred virtually at the same time in the same location with the same purpose. For instance, there's no view of facts that Mr. Mangione stalked Mr. Thompson aside from the actions on the morning of December 4th, 2024. So that's the only time the stalking happened. I wouldn't say that's true. He was stalking him for a while, clearly. It concluded on December 4th, 2024, but he's trying to find the guy for a while. So I don't know if that's true. This is something that they're just sort of shoving in there. This is a lawyer effectively trying to argue their client's position. As prosecutor, if I was writing an opposition to this, I'd be like, what are you talking about? The stalking that was going on there was, we allege happening for weeks, maybe months, certainly days. The whole time he's traveling across state lines, plotting out, that's part of the stalking. Sending the email is part of the stalking. It's not part of the murder charge. It's trying to find out, where is this convention happening? That's all part of the stalking charge. That's not part of murder. The full range of conduct comprised of stalking offense is coterminous with the conduct committed as part of the murder offense. Again, this is his defense counsel talking. They're making this argument. As a result, under subdivision A of the definition of criminal transaction, each or of the two or more acts comprised in his conduct was so closely related and connected to the point in time and circumstance of commission as to constitute a single criminal incident. It's a very interesting argument. I don't think this is a foolish argument. I wouldn't call it necessarily a winning argument, but I'm saying this is something that, I think it would be bad faith to say that this is a complete crap argument. It's definitely not a complete crap argument, because New York defines this very, very broadly. Each of these acts likewise constitute a federal offense of stalking with the purpose of killing Brian Thompson. That Mr. Mangione traveled from one state in order to be at the crime scene at the time of shooting does nothing to eliminate the stalking Mr. Thompson from the acts constituting his murder. They are all part of the same criminal incident, the criminal transaction as defined by CPL 4020. Here, Mr. Mangione is charged separately by the state and federal governments for the same act of shooting and killing Brian Thompson. Now, I actually want to ask Claude if Claude can get his hands on the indictment. Because one of the things I'm noticing here is they tend to be throwing together acts 3 through 10. And it's possible that some of the charges in 3 through 10 are swallowed up by what happened, but that others are not. I think they want to glom them all together. Let Claude figure that part out now. You're saying searching isn't stalking. You stalk after you find someone. How do you get to stalk them without knowing where they are? He's not just, it's not just that he's doing a Google search. He's misleading people in order to find where he is. I don't know. I mean, I agree with you that without actually showing up there, it could not qualify as stalking. But when he's traveling from one state to another, I would say the entire time he's traveling, that's part of the stalking, not just the moment that he's in close enough proximity to see the guy. But I haven't researched that. It's an interesting question you're raising. In case you want to know, when they reference charges 3 through 10 here, it's relatively short. It's a relatively short indictment. So I don't know why it starts as a second count, but the third count it references here is murder in the second degree, which is, basic garden variety murder. Fourth count is criminal possession of a weapon in the second degree. So this is why he was allocuting about the weapon that he built for himself. An armed felony committed as follows: that he possessed a loaded firearm. Under 265.031B, then there's a different criminal possession of a weapon in the second degree. Then there's criminal possession of a weapon in the third degree, in 265.027. And again, in the third degree, 265.02. And they basically are listing off all the different criminal possessions that he could have here in charges, basically in charges 4 through 10. Oops. So 4020-2 provides that person may not be separately prosecuted for 2 offenses based upon the same act or criminal transaction, and that this is all basically one transaction. Now, on August 14th, Mangione pled guilty in federal court to causing Brian Thompson's death through stalking. And I would say it's more through pulling the trigger on his gun, but stalking was a part of it. They want to frame it as through stalking. Stalking wasn't a necessary part of it. I mean, of the death part of it. It could have happened upon him and still would be murder. So the fact that he's stalking also, okay. Under CPL 4020 and 4030 statutory framework, Mangione's federal plea is a prosecution that terminated when he pled guilty. And should bar the state from separately prosecuting Mangione for murder because both prosecutions are based on the same exact act. Accordingly, count 3 indictment charging second-degree murder must be dismissed. In addition to Mr. Mangione's federal stalking plea, there's a second legal basis for barring the second-degree murder count under CPL 4020. Specifically, Mangione was originally charged federally with 4 counts: stalking, murder through use of a firearm, and another firearms offense for using, carrying, or possessing a firearm. On January 30th, Judge Garnett dismissed counts 3 and 4 of the federal indictment. Nevertheless, under CPL 4030, these dismissed counts still can be an independent basis for double jeopardy. So he's saying, since it was, so this is where they're trying to like they're looking to have double jeopardy twisted into like several different ways. The reason that this is not a crazy argument is because New York has the broadest protections for double jeopardy. So you're sort of banking on New York living up to its reputation and trying to find that any way possible. So if there was a charge that was brought in federal courts that got dismissed, that too would count for double jeopardy for a similar charge that arose under the state charge, under the state indictment. And that CPL 4030 states that under New York double jeopardy law, a person is prosecuted for an offense when he's charged therewith with an accusatory instrument, and it terminates or any other jurisdiction within the United States, and the action terminates in a conviction upon plea of guilty. This is funny. This is funny. So they're saying, so you had some charges that were dismissed, and then other charges are pleaded guilty. This is where I think they're going to lose, certainly on the possession charges. Okay? This one, I feel pretty confident they're going to lose on. And this fills my heart with a little bit of warmth that we're going to get some sort of trial here for Mangione. And I'm hopeful we'll get a murder trial for him, not just a possession charge for him. But what are they saying here? They're saying, okay, in order for it to be considered prosecuted, you have to have a guilty plea or a conviction. So that's got to be considered, that's how you get prosecuted. Okay. Now, we don't have that on this on the federal possession charges. Those federal possession charges were dismissed. But since there were federal possession charges and in federal court on other charges he pled guilty, now we wanted the New York State court to look at it as if there was a conviction or some sort of finding on the federal possession charge that would now bar the state possession charge, now preclude a state possession charge. To me, this seems to be such very, very extensive overreaching. Well, in that case, there was some sort of plea of guilty, but it wasn't on those charges. So how the hell is that relevant? I don't think that that's going to work. I really don't think. I'd be very surprised if that works. The language in CPL 4030 is unequivocal. The defendant need only be charged with an offense and that the action which offense was charged be resolved with a plea. Notably, there's no requirement that the defendant plead guilty to every specific offense. So just because he didn't plead guilty to those possession charges doesn't mean we can't wash those away with double jeopardy. Consequently, under the statutory language, just because charges were dismissed before trial does not prevent New York's double jeopardy law from applying as long as the defendant was charged and the action ultimately was terminated by a guilty plea. So he was charged and that was dismissed, and then later there's a guilty plea. So that retroactively should now serve to have the possession charge count as if that's already a double jeopardy situation. I'd be surprised if the New York Court of Appeals goes along with this argument. I'd be very surprised if they go along with this argument. To me, that sounds kind of retarded. It sounds like it sounds like a very draconian read of what the statute is, and a twisted perversion of what the New York State legislature likely intended when they drafted. Accordingly, Mr. Mangione is deemed to have been prosecuted for murder through the use of a firearm in the federal firearms counts, and he was charged with those offenses. While this additional basis for double jeopardy obviously bars the state from prosecuting its state murder charge, because the state murder charge and the federal murder through use of a firearm are based on the same act or criminal transaction, i.e. the murder of Brian Thompson, also bars the state from prosecuting its firearm charges as well. This is where they really are stretching. This is like, sometimes, you start falling so in love with your own legal cleverness that you don't think your farts stink anymore. Like you can't smell how bad how twisted this sounds. And this sounds very twisted to me. This sounds very twisted. So you think your own farts don't stink. I've talked about this in the how I learned this lesson when I was a first-year law student a lifetime ago. 3 decades ago, I learned this lesson. I was taking a legal brief writing class, and I was arguing against another first year. And before we went in for arguments, so first we had to write a brief, and you're writing this for months, and then you come in and argue against your classmate, and I kept thinking how my side definitely is way stronger arguments. And before I went in, my classmate who I was arguing with goes, "Man, I'm so glad I was for the prosecution, he was for the defense." And he's like, "I'm so glad I have the defense, because if I was prosecution, you have nothing. You have nothing." And that's where I learned. I was like, "What? What are you talking about? You have no chance here. You have no legal arguments. These are stupidest arguments in the world that you have." But yeah. Actually, maybe I have it backwards. I think I was defense. Well, that's not a here nor there. The point is that he was convinced that my side had no arguments, and I was convinced that his side had no arguments. And what reality is that it was a very good model in that you really could find a lot to root yourself to on either side of things. On this one, I like the double jeopardy with respect to murder. I think the double jeopardy with respect to murder is pretty decent. I don't know who's going to win. That's pretty decent. But the possession one, you're really straining credulity here a little bit. Let's talk about the exceptions to New York's double jeopardy law that they're claiming do not apply. Because remember, I told you to focus on those exceptions 1, 2, and 4. So CPL 4020 lists 9 exceptions, although none of them exist in this case. Counsel will address the exception listed in CPL 42B, because that's the exception the district attorney's office had tried to rely on in previous cases. In other words, this is where we know they're going. Now, again, just to remind you what 42B was. That was over here. That was over there. This one. A person may not be twice prosecuted for the same offense. Each of the offenses as defined contains an element which is not an element of the other. Or the statutory provisions defining such offense are designed to prevent very different kinds of harm or evil. So let's put your prosecution hats on, put your lawyer hat on for a moment. The other side, defense is coming in here, they're saying, well, what was the charge? The federal charge was this: traveling interstate. So we can't really fixate on that. I would agree with defense counsel, you can't fix on that. And with intent to kill, injure, harass, intimidate, or place under surveillance with intent to kill, injure, harass, or intimidate another person. Now, if I was the prosecution here, I'd be like, this is a crime designed to stop people from stalking people, from following them and scaring the bejesus out of them. That's what this whole thing is. There's an enhancement that comes if somehow it results in this person's death. But the death doesn't even have to be an intentional act by the defendant. In theory, imagine this scenario, okay? Imagine that Luigi Mangione basically was stalking Brian Thompson, pulls out a gun, fires, misses. Brian Thompson starts running, falls, cracks his head open, drops dead. That's under this, that's completely fulfilling this objective of this federal statute. You're stalking the guy, results in his death. You might not pull the trigger, right? You might have been turned away, but the guy running, like freaking out, is afraid you're going to kill him, runs into a car and runs into the street and gets hit by a bus. He might have run like 6 blocks away from you, still running because he's freaked out. You're probably guilty under this statute if you traveled interstate. And you probably with the enhancement of you're stalking him and it leads to the person's death. You think you would get murder for that? I don't know. I don't think you would. Maybe you would get some sort of manslaughter type of thing, a reckless endangerment that leads to murder. I don't think it'd be this. And I do think that this statute, the objective of this statute is don't go stalking and harassing people. And that if they end up dead as a result of your harassment, we're going to come down very hard on you. So that's very different from the intentional taking of another life, which is what murder 2 is. So they're now addressing, so that's what we should expect the prosecution is going to say, that these have 2 different objectives, and there's all sorts of different elements here. That one, you have to actually be following the person trying to harass them. As opposed to murder, the person might not even see the murderer coming. The whole point to murder is don't go killing people. Don't take actions that are designed that you intend to kill someone and you succeed in killing them. Harassing doesn't necessarily even have to be the fundamental part of harassing is not even the person's death. That's like an enhancement that comes later on. The fundamental part is stalking. That's what the prosecution is certainly going to say, or part of what they'll say. For this exception to apply, both factors must be present. Since the statute is written in a conjunctive, as to the first factor, that each offense contains an element that is not an element to the other, counsel acknowledges that the state and federal charges have different elements. So defense is saying, okay, so they're gonna win on the elements part because there are different elements here. It's been well established that this factor alone is not sufficient to trigger this exception. Now understand, the prosecution needs to find an exception. You're right, double jeopardy for one action should bar us from being able to prosecute unless we can find this exception. So the prosecution now is looking for an exception. So how do we have an exception? We have an exception is if it's a different crime with a different objective designed to stop a different evil and it has different elements. So defense for Mangione is saying it does have different elements, but they're going to try now and say it's not trying to stop a different type of harm. The second factor, however, is the problem for the district attorney's office. It cannot establish that the statutory provision defining such offenses are designed to prevent very different kinds of harm or evil. As the Court of Appeals has noted, although the different harm or evil exception could have been potentially quite broad, it has been legislatively narrowed by the requirement that the harm or evil to be addressed by the separate prosecutions be analyzed by reference to statutory provisions defining such offenses, rather than to the particular criminal acts charged, citing Kaplan v. Ritter. Accordingly, the demanding requirements to establish the exception under 2B looks not to the evil toward which the particular prosecution was directed, but rather to the broader evil to which the penal statute in question was addressed. Okay. Given the broad protections in New York double jeopardy law and the demanding requirements of CPL 4022B exception, it's clear that the statutory exception in line with providing broader protection against double jeopardy contemplates a significant and meaningful difference in the type of harms addressed. So what the defense is claiming here is it's got to be a very different kind of harm if you want if the prosecution wants to have this exception to double jeopardy. Put differently, where the harms or evils contemplated by the differing statutes are generally similar, the courts will find that the exception under CPL 42B does not apply. In examining the harms or evils, so that's the general rule. This is when you're doing IRAC. First, you have the issue. This is the general rule. Now they're going to try and apply it in a way that's going to draw to the conclusion they're hoping for. So the rule is it's got to be something that it's got to be a meaningful difference on the type of harm being addressed. So you have to have a meaningful difference between murder and this stalking. And examining the harms or evil addressed by different statutory schemes, the court should be mindful that the legislature requires the schemes address very different kinds of harm or evil. Mere differences or slight differences don't help the prosecution. Okay, kinds of harm or evil addressed by statute must be very different from each other. other, and then they cite this Wiley versus Altman. This is still trying to, so they're saying Wiley versus Altman, the defendant was prosecuted in New York for murder and in Maryland for conspiracy to commit the same murder. That's not really the same thing. So that over there was a double jeopardy. Okay, but that's murder, attempted murder. That's not really the same thing as stalking versus murder. The court then analyzed prosecution's claim that different kind of harm or evil. The court rejected the prosecution's argument, and the court noted that although the defendant was charged with conspiracy, not murder, the conspiracy charge permitted the same punishment as that prescribed by the object crime. Okay, so that's conspiracy to do the same exact act. That's not the same thing as. In order for Mangione to win, he's got to basically say stalking that leads to death is the same thing. Is trying to stop the same harm as a general don't commit murder. So if this is the best that they have, and they usually start with their best, that's not a great sign for Mangione. Same analysis applies in this case, and results should be the same. As noted in Wiley v. Altman, the goal of New York's murder statute is punishment of the unlawful taking of a particular human life. Under the second basis of double jeopardy argued above that the state murder charge is barred because of the federal murder through use of a firearm charge, both statutes involve murder and both share the same exact goal. Do they? Yeah. Look. Under the enhanced stalking, it is certainly designed to have people not end up dead after being stalked. So it's not a crazy argument. It's definitely stronger than the weapons possession argument. The statute prohibits the defendant from traveling interstate, blah, blah, blah. In addition, the penalty provision of the stalking statute specifically provides that if the victim dies as a result of the defendant's violation of the stalking, the defendant shall be imprisoned for life of any term of years. Accordingly, when all aspects of the federal stalking statute are read together, it also punishes the defendant for the unlawful taking of particular human life, the same as murder statute. That's really the best argument that they have. That's the best argument that they have. And it could win. This argument could win in court. I wouldn't be astonished if the appellate court, if the court found in Mangione's favor on this. Use of a firearm offense was dismissed by Garnett with a single difference. The murder charge is punishable under the murder statute by a death penalty, and stalking offense punished by a maximum of life in prison. The sentencing guidelines calculation for the two offenses, however, is precisely the same. This shows that the gravamen of stalking with intent to kill and the murder offense is the same. That's a great argument. The loss of human life requiring the highest degree of punishment available under the law. And if you want to argue this realistically, if you really want to argue this realistically, okay, and philosophically, so I think it's important to have intellectual integrity with you. Philosophically, to be fair, and I think this guy Mangione is very evil. I think he's very, very evil. But here's. Let's be fair. Let's think this through. The reason he's stalking him is he wants the guy dead. So you can look at it as he's trying to commit murder here, and that's a step towards murder. The federal government wants to have a reason to come after them, so they're like, "Oh, there's stalking here, so now we can come after him for the murder." The real reason they're coming after him is because he killed the guy. He executed him. So in that sense, that is the government trying to use the law that's available to them to hang this guy for murder. I mean, that is objectively what's happening here. So if you look at it from that philosophical perspective, I can understand a court concluding and saying, this is sufficiently similar that with respect to the murder charge, I'm going to say this is double jeopardy. Maybe not on the weapons charge, because he didn't really face any weapons charge in federal court. And just because he later pleads on the murder doesn't mean that that would now turn this into a situation where he's faced jeopardy a first time on the possession, because I don't think he did. But I can understand someone philosophically saying, let's call a spade a spade. Derek Chauvin, when he was being prosecuted once for abuse of civil rights and killing someone, and also for murder in Minnesota, they're both going after him for murder. That's what they're trying to do. So if you ask me my gut, like, what does it feel like the federal government's trying to do here? I think they want to get him for murdering the guy. I think they do. And if you look at it from that, just, 5 miles high in the sky, looking down at this incident and what the different roles are playing here, the federal government, the state government, they both trying to get him for the murder. And in that sense, once he's pled in one place, I can understand a court saying that's double jeopardy to face it a second time. So I can go either way on this. I really can go either way, but I can definitely, I think on the possessions charge, it's ridiculous to say there's double jeopardy here. But on the murder charge, I think this is a very shrewd tactic. Now, the reason that this is a little bit of a very questionable tactic, what makes this a little bit of a crazy strategy, is we cannot lose sight of the fact that this guy is crazy popular. I mean, insanely popular, ridiculously popular. I mean, there are lunatics, crazy people out there. I'm going to show you a video here. I was watching Michael Knowles was sharing and this is, it's insanity how popular this guy is. Insane. Let me show you this. Find this one real quick. Take a second. Right.
Free online course on Homer's great epic, The
This is what Michael Knowles shared out. It's craziness.
Right. Surely they're going to recant of their support for Luigi.
He's saying, like, once this guy pleads guilty to murder, you would think they would recant. All these people who are professing their love for Luigi would recant. Not so much.
Not so. Here's what one of them says.
Do you think it's wrong that he murdered someone regardless of why he did it? Everyone has a different opinion, and I'm not going to say it was wrong or right because I do think I exist within a gray area of the opinions around this case, but I see it more as a revolutionary act of protest of the likes of which we haven't seen since the civil rights era. My reactions in court, relief, I guess is the word. I think for a very long time people have ascribed this idea that supporters are painting him out to be guilty by having conversations about the healthcare industry. So to no longer have to fight that battle is satisfying and relieving. He has a lot of battles to fight. I want him to be happy and healthy, but I want America to continue questioning, our current predicaments and why we allow our futures to be stolen away by oligarchs.
The online bros who campaign for repeal of the 19th Amendment, they have met their spokeswoman. Here she is. This is it. The face of 19th.
Now, all you need is one of these idiots, and there's countless of
19th Amendment repeal, and there are a bunch of women like her outside the courtroom.
They're literally they're sufficiently vested that they're gathering outside the courtroom, holding up signs for him. This is what made the reason I bring this up is this does throw a little bit of shade on the strategy of pleading guilty. In that you think you can't find one of these people to sit on your jury? Can't find one of them? You find one of them, he doesn't get any jail time. But look, as Ron Coleman says, you don't take the case unless you have you can't judge a strategy without having the red well. So they clearly felt like this guy's gonna get cooked. He's very guilty and he's going to get cooked. And they weren't confident that they would basically have jury nullification in order to help him out from this, which is what they would essentially be seeking. So they basically felt that this was this was a dog case. And they're hoping they can get him club fed instead of getting a state conviction. A lot of people have thoughts on this. I'll share a couple of them with you.
Minutes didn't go by before he pled guilty in that courtroom when his lawyers ran into state court with a 30-plus page filing saying why the state charges should be tossed out. They're relying on a New York law, which is friendly to defendants, but the path forward here is anything but clear as to whether this law, which he says you can't be tried for the same criminal transaction twice, is actually going to be something that he gets the benefit of. That's going to be up to the state court judge to decide.
Something that I think is really interesting, and maybe the reason why, right after his allocution, they hit the, the file button on the state court docket. They have laid out, Mr. Mangione has now pled guilty to the crime he committed, possessing a single gun that he fired at a single person, Brian Thompson, on the morning of December 4th, 2024. In a single place. So they've really laid it out. He said,
which is not what he's been charged with in federal court, by the way.
No, but they've laid it out. Do you see the way they laid it out factually, though?
Yes, they're trying to include everything.
Right, this is it.
Which is normally a defendant wants to include nothing.
They want to be like, the most limited amount of things that I need to say is what I will say.
But here he wants everything. He wants everything in the stew so that he can get it all kicked out.
Right, because they want to say, look at what the basis for the federal plea is. Look what Luigi Mangione said before Judge Garnett. Those are the same facts. That's the same thing as what he's being charged with in state court. And Laura, I actually think it's going to be a bit of a novel issue.
I happen to agree. I think this is a bit of a novel issue.
They can show it's manipulated.
I think it is a bit of a novel issue. I think this is a little bit of a difficult situation. If you're the prosecutor, you're not crazy about the situation today. You have concerns because this is an internationally known case, and if it blows up in your face that you lose this because of double jeopardy, people are going to be looking at you and they're going to be asking all sorts of questions as to whether or not you did a good job here. So there's a lot of pressure for them. There's a couple more clips I wanted to share with you, not this one. This one is one I want to.
Luigi Mangione had his day in federal court. $1 billion in assets to learn the whereabouts of the
maximum penalty allowed, life imprisonment, which, as I've conveyed to Mr. Thompson's family, is what we intend to see here.
The Thompson family saying in a statement afterwards, the guilty plea marks an important step toward justice for Brian and for our family, adding, now we look to the court to ensure that sentencing reflects the severity of this crime. Mangione is set to be sentenced for his federal crimes on December 18th, but he's also...
I'll ask you this question. Do you think the fact that he's become an international celebrity should weigh in the factor as far as the severity of the punishment? Because I actually think justice dictates that he gets a stiffer penalty because of the public acclaim he's gotten. And this might be not a popular thing to say. I'm not sure. But I think the fact that he's become this celebrity as a result of committing this heinous act pushes justice towards saying, punish him all the harder and give him the full maximum rest of your life without possibility of parole. Because of the fact that he's become, because you can't have people think that this is something that's going to be okay. You gotta say no, 0. He's saying for sure. You can't get, the death has been taken off the table. You can't get that.
Facing second-degree murder and weapons charges in New York State Court in a trial slated to begin September 8th. His attorneys immediately filing a motion to dismiss the state case on the grounds of double jeopardy.
It was a single tragic event, yet he's being prosecuted twice for the same conduct.
And while the fate of that state case remains unresolved, his confession in federal court was crystal clear.
The days of Luigi Mangione saying, I didn't do it, pleading not guilty, are over. If the state trial does go forward, he'll have to raise some type of defense that actually concedes that he committed the crime.
Now, the Manhattan DA's office says that they are prepared to argue.
And she's actually touching on a really interesting point here. Like, I haven't looked into this. I would assume the state could use his admission there against him to get a conviction. He said he did it. I don't think that that's barred. Now, maybe that's how the court will try to split the difference and saying we're going to preclude you from using this statement. But if there is a murder trial for Luigi Mangione on the state level, I think that there's going to be so much litigation about this, about double jeopardy, about use of the statement, that there's going to be motions in limine to try and keep him from being able to use the statement that he made in court. But yeah, that's a really interesting question.
The state case, but are waiting for clarity on federal sentencing. The federal judge here could certainly sentence Mangione to life behind bars. She told the court she's going to be factoring a lot of things into that decision, including his words, the pre-sentencing report, and the probation report. And guys, to be clear, the Thompson family said in their statement they do want the New York and Pennsylvania cases to proceed. As for that double jeopardy question,
no, that wasn't the one I wanted. This is the one I want. Let's go. This lawyer over here, I don't remember what his name is. Maybe they'll give us his name.
Across multiple states. We told you yesterday about the discussions happening between the defense and prosecution in this case. Sources tell CBS News his guilty plea could come today, less than a month before his state trial was set to begin. Joe Tamburino is an attorney and legal analyst. He joins us now with more on this. Joe, good morning. First off, we want to be clear, nothing is final here until it's announced in court. But does it make sense for Mangione to plead guilty in his federal case when he's also facing state charges?
Good morning, Michael. Thank you for having me on. Yes, I think it would make sense for him because in any type of plea negotiation and any type of plea deal, both sides get something. So I'm sure what Mr. Mangione is trying to do is see if he can get a sentence of anything rather than life in prison because he's only 28 years old. And I'm sure he's going to try to work out a deal where he could still walk out of prison alive rather than spending his whole life there.
And Joe, in your opinion, would the double jeopardy argument apply in his state case if he enters a guilty plea today in the federal case?
No, I don't think it would. And
he's basically, and he's going to break down 2040 subsection 2B.
That's for this reason. New York's double jeopardy law has a number of exceptions. And one of those exceptions is when you have two different types of charges from different sovereigns or different governments, the state and the federal, and those charges involve different elements, meaning components to a crime, and the charges are preventing different types of harm. So in this case, we have New York law, which has intentional murder, and that has different elements than in the federal charge of stalking. And New York's law is trying to prevent intentional murders, whereas the federal government is trying to prevent stalking or crossing state lines to stalk a victim and the victim dies. So we have two different types of charges with different elements, and those charges are designed to prevent different types of harm. So
the question is, how radically different does it have to be?
I don't think
this is definitely going to be something that the appellate court's going to be struggling to grapple with.
Jeopardy would prevent New York State from continuing with their prosecution.
So if the state case does proceed, could a guilty plea in the federal case affect or delay the state trial?
Yes, it could. And that's only normal because if you're resolving your federal case, that's the first one that's being resolved, and then you go into state court, many times it wouldn't make sense to have a trial in that state court. You would try to work out another deal. Why would you do that? Because you want to see if you could have the two cases in tandem, meaning that they're going to make sense with each other. or you want to have the two cases run concurrently, which means you're not going to get additional time for one or time on top of whatever you're already serving in the first case. So yes, I think it would make sense to try to resolve the state case after this federal plea.
All right, Joe Tamburino, thanks for joining.
So lots left to sort of mull over, but he seems to be convinced that this is going to be something that the appellate court in New York is going to rule against Mangione. I'm not that confident. I think this is toss of a coin. This is really toss of a coin. I'm leaning on his side, but it's toss of a coin. I wouldn't be surprised at all if it goes the other way. But I'll definitely keep you apprised of other further developments in that when he's found how that legal issue sorts out and whether or not there's going to be a state trial. If in fact there is a state murder trial, I plan on covering that. I plan on going down to New York to cover that. I don't think it'll be a long trial. I think it'll be a relatively short trial. But I definitely plan on going down to cover that if in fact there is a state murder trial. I'd be shocked if it happens within the next year, even if there is a trial, because I think the appeal is going to be going on and on and on about what they can bring in. Can they bring in the state? Can they have a trial? If they can have a trial, can they bring in the statements that he made in federal court, the confession that he made in federal court, which seems like it would be turn the case into a slam dunk for the state. It's an interesting thing. And from insane Mangione fans on the left to the Democratic Party. This was a significant weekend for the Democratic Party. The reason this was a significant weekend is because they actually, I think that they did something that was so short-sighted with respect to the position that the entire Democratic Party is now taking, as expressed by Ro Khanna.
And when I say we stand with workers, that includes our friends and neighbors who prepare our food, build our homes, and care for our children. That is why we must abolish ICE.
Abolish ICE. That is a clip every Republican candidate needs to play over and over again from now to November 3rd. Senator Ro Khanna, I know he's not a senator. I keep calling him a senator. House member Ro Khanna saying abolish ICE.
It is a cruel, rogue agency.
Now he tries to walk it back a little bit here.
It is an agency, and you know this, that murdered Lorenzo Salgado, replace ICE with an immigration agency like we had from the New Deal until George W. Bush that works under justice. Here's what I want to say about this. When they shot Lorenzo, and I don't know if you saw his kids, well-educated, polite kids. When they shot Lorenzo, a construction worker, a 52-year-old father
with three
polite, well-raised children, they shot the American dream.
That's crap.
That's what they shot, those ICE officers.
You're an idiot.
And when I say
you're an idiot. Yeah, that is something we need to play this over and over again. Clip the hell out of this. Lunacy. There's Tom Homan responding to this idiocy.
Governor Newsom, Mayor Mondami, Governor Hochul, I want you to listen to that tape of that murder.
Let me boost the volume here a little bit.
And listen to that little girl fight for every breath. Listen to the terror in her voice. This little girl fought to stay alive. Listen to that tape, then tell me that you totally justify what you're doing with sanctuary cities. You can't square that. And Governor Newsom.
It's astonishing that they would, in the summer before, as we're heading into election season, that they would take a position of abolish ICE. And look at the comments here. What's the point of being an opposition party? Democrats disagree over abolishing or reforming ICE at DNC meeting. The question, what's the point of being an opposition party? This is someone's got 11,000 followers basically saying, how are we not abolishing ICE? How are we not how can any Democrat stand against that? Sean Farish saying, if you're even considering voting Democrat, they're the party of open borders, defund the police, abolish ICE, pack the Supreme Court, abolish presidency, abolish the Senate, confiscation of private property, increasing taxes, abolish prisons. And nothing you can say can be taken seriously. There's another leftist, 297,000 followers, all pissed off that some Democrats are disagreeing about abolishing ICE. They're lunatics. They're utter lunatics. This guy, Chris Jackson, I don't know who he is. He's a small account, but he's basically, I'll not support any Democrat who can't meet the bare minimum of abolishing and prosecuting ICE. The Democratic National Committee adopted a resolution Saturday urging congressional Democrats to abolish immigration and customs enforcement alongside a competing measure calling only for reforms to the agency at the party's summer meeting in Austin. The abolition measure, known as Resolution 27, cleared the DNC's Resolutions Committee on Thursday in a 25-12 vote with one abstention before heading to the full membership. Both resolutions were bundled into a larger package and approved by the full membership of unanimous voice votes. The reform measure, sponsored by DNC Chairman Ken Martin, drew broader support in committee than the abolition proposal. So they're the ones who just want to reform rather than abolish it altogether. The vote comes amid internal party debates over immigration policy ahead of this year's midterm elections as President Donald Trump expands deportation efforts. In July, Border czar Tom Homan said ICE was on schedule to set arrest records for a second consecutive month and described the push as deportation maxing.
Of arrests in the history. And in June, we had the highest numbers of arrests in the history of the agency, of ICE. And July is tracking to even beat that. So we're hitting on all cylinders now. We're deportation maxing. Since we're fully funded, we just got to keep going. And then June.
So there you go. The resolution calls on Democratic members of Congress to enact legislation dissolving ICE and winding down the immigration detention system. It seeks to restrict Department of Homeland Security. They want to have no borders, zero borders, no borders at all. Just come here, take whatever you want, and the rich will pay for it. The rich will pay for it. Martin said official party platforms are set every 4 years at the National Convention, argued Democrats are still united in opposing the administration's enforcement approach, even as they split over what should replace it. Our official party positions are determined at the convention every 4 years, so this is not our official position. Then you're really stupid for putting this out there. They think this is going to help them in the elections? I'm sorry. That's insane. Extreme radical Democrats want to abolish ICE and defund the police. Instead of trying to abolish ICE, Democrats should be thanking ICE law enforcement officers for putting their lives on the line to arrest and remove murderers, rapists, pedophiles, and gang members from American communities. Many of these communities were released as criminals released from jails by Democrat radical politicians. I'm going to tell you right now, you should be thanking God for this. This is awesome. This is awesome news. I'm taking the position that this is what's really happening. Why are they coming to this now? When Ken Martin's coming out there saying our official position only comes out every 4 years, and we had one 2 years ago, so this is not our official position, but we are issuing this resolution. Why would you be doing this? Why are they doing this? You know why they're doing this. You know why they're doing it. It's because they're afraid of the DSA. So they are slowly morphing into the DSA without taking the term socialist into their name. What they are steadily doing is they are devolving into becoming the Democratic Socialists of America without actually calling themselves Democratic Socialists of America. This way they feel like they can appease the lunatics in their party and not have their political heads sliced off, guillotined, dropped into a basket, and carted off to be put up on spikes by the lunatics socialists. And that's what this is about. They want to basically say, don't worry, we're going to give you everything. We're going to give you everything. We're just not calling ourselves socialists. That's what this is. That's exactly what you're seeing here. Anyway. And so that's why when socialists win, we should say huzzah. We should say huzzah, because there's no difference. There's no difference. They're indistinguishable from each other. And since they're indistinguishable, the ones who are open enough and brave enough to call themselves socialists, they're the ones who will struggle more in a general election. So much more so than the snakes who try to pretend that, like, you know, they're one of the good Democrats. There's no such thing as a good Democrat. That does not exist and has not existed in quite some time. And with that, I am going to land my plane over here. I thank you all for joining me. God willing, tomorrow evening I'll be back, probably a little bit earlier tomorrow than I was today. And I want to remind you to check out the merch, our merch store. If in fact you haven't gotten your merch yet, you probably should get on that. And I'm going to remind you that it was not meant for you. It's meant for they, them, who is, you know, certainly associated as Democrats. And do not eat the bugs. Don't do it. Have a good night, everyone. As always, Godspeed.